We did it on both.
Denzel Spikes.
Yes.
Okay, you're Denzel Spikes.
Yes, ma'am.
Will your client waive the formal reading of the motion and the indictment?
He does, yes.
Judge, we're just proceed on count one. I mean, on allegation number one, we'll ban the rest. That is the condition.
Mr. Spikes, in cause number 25, DCCR 0921, you're charged with the second-degree felony offense of aggravated assault with a deadly weapon from April 29th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents in that case that have your signature on them that the state's marked as exhibit number 1. I'm going to need some explanation.
On
The punishment.
his 3, Judge,
He's on probation for aggravated assault with a deadly weapon, commits another one.
the newest one was not as egregious as it seems. It was a kind of a mutual combat, but
Okay, let me look at
therefore we're proceeding on that with the lower bar to the nature of it, but not to continue him on probation.
Okay, give me a second.
The courtroom quiets as Denzel Spikes steps forward. The formal reading is waived and the focus is on a single allegation. He faces a second-degree felony aggravated assault with a deadly weapon. He pleads guilty freely and voluntarily admitting he did exactly what is accused of. Documents are reviewed, signed, and entered into evidence. The judge notes the context. Spikes is already on probation for a similar violent offense. The new incident, though serious, is treated with nuance. It's described as mutual combat rather than outright aggression, which influences the court's approach. The hearing pauses briefly as the judge sorts through details and considers the proper course of action. Even small variations in circumstances can affect outcomes, but accountability remains central.
So give me just a second. I'm going through a couple things. Okay. All right. So I have, again, some paperwork here that has your signature on it. Did you go over that with Mr. Lewis?
Yes, ma'am.
Do you fully understand it?
Yes, ma'am.
And do you understand, if I follow the agreement that you've reached with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
The judge pauses, reviewing the paperwork, prior case files, and the pre-sentence report. Every detail matters past offenses, the nature of the new charge, and the potential risks of leniency. Spikes confirms he reviewed all documents with his attorney, understands them fully, and knows that pleading guilty waives his right to appeal. He also acknowledges the immigration consequences if is not a U.S. citizen. The court notes concern over the pattern of violence, grabbing objects, striking other 7 if the latest incident involved mutual combat. Still, his lack of prior criminal history is acknowledged. The state confirms the charges, no objections are raised, and competency is affirmed. The stage is set. The plea is entered, responsibility accepted, and the focus now shifts to sentencing and the consequences that follow.
Look at one more thing before I do this. Let's see, 24. printing something. Bless you.
Thank you.
I'm just looking now at the PC from the original case. I'm looking at
The court moves decisively. Denzel Spike's plea is accepted freely voluntarily with full understanding of the consequences. He is found mentally competent and the evidence supports a conviction. The charge, aggravated assault with a deadly weapon. The sentence is set, 3 years in the Texas Department of Corrections with credit for time already served. Attention then turns to probation. His earlier 10-year deferred probation for the same offense is at stake. The state proceeds on the single count tied to the new assault. Spikes admits the truth of the violation, acknowledges the paperwork he signed with his attorney, and understands that following the plea agreement waives any right to appeal. Responsibility is clear, consequences are real, and the path forward is now fully defined by the court.
the PC from the new case. Let me see if I can go back. I'm also going to take a look real quick at the PSI. I'm just not feeling real comfortable with that low. I understand in the new case, potentially some issues if there was some mutual combat, but the underlying offense and the fact that we're resorting to the same thing and grabbing things and beating people with them is concerning.
The courtroom falls silent as the judgment is finalized. Denzel Spike's plea to the probation violation is accepted freely voluntarily and with full understanding. Count 1 is found true and sufficient evidence confirms his guilt. He is convicted of aggravated assault with a deadly weapon and sentenced to 3 years in the Texas Department of Corrections with credit for time already served. The court makes an affirmative finding of a deadly weapon in each case, underscoring the seriousness of the offenses. Spikes receives formal documentation, trial court certifications confirming his agreements and waiver of appeal, along with written admonishments about his ineligibility to possess firearms or ammunition under Texas law. The warning is clear: any violation could trigger new charges. With responsibilities outlined and consequences defined, he is returned to custody. The court's message firm and unmistakable: accountability is non-negotiable.
No criminal history. All right, state tenders number 1 in 25 DCCR 0921.
No objection, Judge.
It's admitted. Any evidence Mr. Spikes is not competent.
No, Judge.
All right, sir. In cause number 25 DCCR 0921, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty, and at this time find you guilty of aggravated assault with a deadly weapon. Sentence you in accordance with your agreement to a term of 3 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 24 DCCR 1642, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation December 18th of 2024 for the second-degree felony offense of aggravated assault with a deadly weapon, and that was a 10-year deferred probation. Is that correct?
Yes, ma'am.
It alleges, and the state's elected to proceed on count one only. It alleges that you committed the new offense of aggravated assault that we just, with a deadly weapon, the one that we just went through, April 29th of 2025. And is that true or not true?
True.
Did you enter your plea of true to count one freely and voluntarily? And did you plead true to that count because it's actually true? I have here on the tablet also some paperwork in that case that has your signature on it. Before you signed it, did you go over it with Mr. Lewis?
Yes.
Do you fully understand it?
Yes, ma'am.
And do you understand, again, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? State tenders number one.
Objection.
It's admitted. Mr. Spikes, I'm going to find that you entered your plea of true to count one freely and voluntarily. Find that count true. Find sufficient evidence to find you guilty, and at this time find you guilty of aggravated assault with a deadly weapon. Sentence you in accordance with your agreement to a term of 3 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I am making an affirmative finding of a deadly weapon in each of these cases. I'm handing you the trial court certification in each case that shows these were agreements that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lewis. Good luck to you, sir. You can go back with the bailiff. Thank you, ma'am, for being here.
Thank you.